Good morning.
Good morning, Your Honors. May it please the Court. Bennett Wills for the appellant. I'd like to reserve 5 minutes on rebuttal, please.
5 minutes, yes, sir.
And may it please the Court again, this appeal, this is a domestic case, asks whether a trial court can disregard a court-approved marital dissolution agreement and impose post-majority and retroactive child support in contravention of TCA 36-5-101. And the answer to that is it may not. This is not a case whether continued support of an adult disabled child, or rather not child anymore, but a disabled adult, should receive continuing support. But this is an issue of a court finding that a marital dissolution agreement is unenforceable. So I'm going to address 3 points this morning. Whether the termination provision in the marital dissolution agreement was binding and enforceable, why Tennessee statutes limit post-majority support, and why those limits were ignored here by the trial court, and also why the trial court erred in awarding indefinite adult dependent support. So the first issue is that the trial court lacked authority to invalidate the MDA. The marital dissolution agreement, in this case, is a binding contract. Here, it was incorporated into a final decree of divorce and becomes
MDAs certainly are binding contracts, but the subject of child support is a special category that typically the courts control even post-contract. So how do you avoid the application of child support exception to parents or parties, spouses contracting to other rights?
Child support in this case is controlled by TCA 36-5-101. And so while parties cannot normally enter into a marital dissolution agreement to control child support, in this matter, because it's adult dependent support, that falls into the exception under this statutory authority. So the case of Barnes versus Barnes and Iberbach make it clear that the court cannot modify this MDA for post-modification of post-majority support. I'm sorry. So.
But there was a 2008 amendment to the statute. Was that the year?
I don't recall the specific year of the amendment. I think you're referring to 36-5-101K2.
Yes.
And the statute here, to answer your question, applies only under specific findings. And in this case, the trial court didn't make any of the required findings. There's not a dispute that Channing, the adult dependent, has disabilities. However, there was no formal incapacity determination. There was no best interest analysis, if you look at the plan.
Well, didn't Circuit Judge Clara Bird find the child was severely disabled, and didn't the domestic judge Hagan adopt all findings by Judge Bird after the case was transferred?
Not in the final order.
Well, if he did in previous orders, it's not nullified by a final order unless the final order says to the contrary.
I agree with you. And so there's a couple of orders at issue here. And then to piggyback on that, the other issue too is that Judge Hagan awarded indefinite support, which exceeds his authority under 36-5-101K2. The statute specifically here, whether or not we award support, is whether it's for an indefinite period of time. And then we also have the retroactive support issue. So under the statutory scheme, an order requiring support indefinitely, Judge Hagan can't do that. It's specifically prohibited by 36-5-101K2. Pardon, 36-5-101F1.
Well, what would cure that? Would the judge have to make a finding until the child dies, or until and unless the child is no longer severely disabled? What is the qualifying terminology to avoid indefinite?
The legislature here didn't put that in there, but under 36.5.101, especially in Judge Hagan too, just said until the parties file for a modification. I think there's a statutory issue, but it does specifically say that it's not for a indefinite
Didn't
time.
Judge Hagan say that the father could come back to court if his income increased or decreased?
That's correct.
To modify?
And that's, I believe, under any type of child support issue,
Yeah, I agree.
minor or adult dependent.
But didn't this order clearly contemplate that your client had the right to go back to court if circumstances changed?
It did. But the overarching issue is really that adult dependent support is statutory in nature, and here the trial court lacks the authority to invalidate the terms of a marital dissolution agreement. Here, again, the parties agreed
But
that.
I want to go back to that. I want to make sure I understand what is in dispute here. It sounds like there might not be a dispute, a factual dispute, that the child is disabled within the meaning of the ADA. Is that correct?
That's correct.
Okay. So are you saying that the real issue is whether the child is severely disabled?
No,
Or
Your
is that not an issue at all?
That's not an issue here.
And do we know that the child was severely disabled as of the entry of the MDA?
Yes.
Okay, so those boxes have been checked.
That's correct, and
Okay.
that's kind of coming back to the primary issue, is the child was disabled at the time the parties signed this marital dissolution agreement. They contemplated that fact, they negotiated the agreement, and they agreed that the child support or adult dependent support in this matter would terminate as of Channing's 25th birthday, which was in March of 2022.
But do they have the right to contractually take the trial court's continuing jurisdiction away from it when it deals with child support? All the cases I'm familiar with say parents can contract all day long, but they can't take the jurisdiction away from the court when it comes to child support.
That's a great question. I don't believe this is a jurisdictional issue. This is more of a question of, well, if we say court's authority under jurisdiction, the case of Barnes versus Barnes, I think makes it clear that courts lack authority to modify a marital dissolution agreement unless the modification is grounded in a statute or.
But that case didn't deal with child support, did it?
The Barnes case was specific to that a marital dissolution agreements are contracts, and courts do lack authority to modify or invalidate.
But did it deal with child support?
It did not.
Okay.
It was just a marital dissolution.
Yeah, I think that's the key difference here.
But-
If they're contracting as to who gets half of the house or 20% and who gets this piece of furniture and how much alimony, that's different from child support, at least my understanding it is.
Well, then we have the case of Long versus McAllister. That Tennessee Court of Appeals in that case, 2006, held that except as child support, as is governed by statute, which is the case here, MDA provisions are enforceable as contract obligations. The distinguishing factor is that this is not child support, this is adult dependent support.
But it arises out of the concept of child support. The whole concept is that this soon-to-be adult is severely disabled and will not be able to make his or her own decisions and what have you. But anyway, go ahead.
Well, in the record, we have findings that the disabled adult is able to get a job, is able to make some decisions, is not completely disabled. And I'll point out, too, that Judge Hagan pointed out a public policy, but he didn't cite any statutory authority in his findings and his orders. So really, the overarching point here is that there is a distinguishing factor between child support and adult dependent support, and here the MDA.
Yeah, so I'm trying to just understand if there's some nuance here that I'm missing of your argument. the last amendment to the statute that we care about was '08. This agreement was entered into in 2015. And so is it your position then, had the parties agreed at that stage that support would be ongoing because the child here is severely disabled, that would have been fine under K2. That's something they could do. But because K2 contemplates that type of position and the parties nonetheless agreed that it would terminate at 25, that will always foreclose a court from revisiting that issue? Am I saying that correctly?
If I understand your question correctly, you're asking whether or not the parties can foreclose that issue in a marital dissolution agreement. I would say the answer is yes. And I would draw the court's attention to the cases of Barnes and Iverbach again, that it then becomes, after majority, an issue of contract, not an issue of child support.
Yeah, so, I mean, but what about the interest of the child in this case, which, you know, I think what our case law seems to indicate is that we want to protect that because the parents may not adequately protect it in what they ultimately agree. The parents want out of the marriage, and so they make a decision in their own self-interest, you know, perhaps unknowingly or unintentionally, but the child's interest gets hurt here as a result.
Well, that's a good point, but this case is not whether, not about whether continued support for a disabled adult is desirable. I think my client is willing to pay something. This is about whether a trial court can invalidate a marital dissolution agreement, and it's about judicial authority. So when we remove the moral side of it and we just look at the legal aspect, that's what we're here on.
All right, thank you very much.
Thank
We'll
you.
hear from you on rebuttal. Ms. McCarter, good morning.
Good morning. I'm Elizabeth McCarter of the Nashville Bar. Along with my co-counsel, Stephen Hart, we are representing the appellee, Karla Reichert. May it please the court, the issues in this case are not governed by principles of contract law, despite the parties having entered into a marital dissolution agreement that addressed child support years ago. Our legislature has made a clear policy choice. Decisions regarding the continuation of child support for a severely disabled child, including a severely disabled adult child, are to be given over to a court. And nothing makes this more plain than the language in the amendments to the child support statute itself, 36-5-101. Those amendments, as have been referenced, were in 1999 and then later in 2008. Now, we'll concede that the child support statute in 101 is detailed to a degree that is almost Byzantine, given its length and its breadth. But notwithstanding some of the provisions that reference 5-year limitations or retroactive support, none of those provisions apply here, much less negate the continuation of child support provisions in 101K, which is what controls here. Now, beyond the language in the statute itself, which we believe is quite clear, the case law interpreting it has given trial courts wide discretion on matters of child support for children with severe disabilities, including adult children. Now, we believe the cases such as Lillard, which we've cited, Cook v. Hess, Niemeyer, all of those evince a clear pattern of giving courts considerable discretion, even when a trial court may not have made very specific factual findings, may not have made even all the necessary findings under 101K. Still, the appellate courts have the authority to do de novo review, and that's evidenced in some of the case law we cited that the courts routinely do that. That's not necessary in the instant case, because we have a record that is replete with references to the disability status of this child, Channing Reichert. The guardian ad litem's report, which was issued in 2023, detailed specifically that she was unable to drive, she's unable to make certain decisions, medical decisions, financial decisions. She needs assistance with certain personal matters of hygiene. She can't cook. She can't be left alone at certain times. And this was also supported by medical records. We have a deposition from Dr. Robert Steves. We have a medical affidavit, in effect, from Dr. Hamby, all referencing the fact that Channing Reichert is severely disabled, even as an adult. And we know from the record, furthermore, that Judge Hagan, in his order in November of 2024, specifically found that she was severely disabled before she turned 18. So all of this reflects the fact that there is evidence to justify continued support for this child indefinitely if it is necessary, and it is necessary here. Because really, when you have an adult child with this degree of severe disability, that puts the adult really in the same shoes as a minor. Both are going to need the care and supervision of an adult parent from here on out. And the condition that she was born with, microcephaly, which means, I believe, an underdeveloped brain, combined with her autism and her anxiety disorder, all signify that she's not likely to improve in the future. So that justifies the continuation of these payments. And for those reasons, we believe that the trial court was correct, and we respectfully ask that this court affirm the trial court's judgment.
What do you say about the indefinite nature of the award?
Well, if you look at Section 101K, both parts 1 and 2, it's very detailed, but even when you get to the end and the last provided however clause, there's no duration limitation in any of that language. There's nothing that says that the best interests as defined by a certain date. It simply says, as according to the best interests of the child and as may be necessary for care and supervision by the parent. No time limit is specified in there, and that was for a reason. Because a severe disability such as this is unlikely to improve. So the courts have to have that leeway, we believe, to address that. And even in the case, I think it was Cook v. Hess, where you had a marital dissolution agreement that had a provision in it that said until emancipation as determined by the court. That was wide open. Emancipation as determined by the court, that could be tomorrow, that could be 5 years from now, it could be never. And that's the reason we believe the legislature left it wide open in 101K, and it needs to be that way.
The point has been made that the parent's child is no longer a child in the sense of no longer under the disability of minority. Do you believe that the statute 101K contemplates that this now adult, severely disabled adult, shall be afforded the benefits of the concept of child support even after obtaining adulthood?
Absolutely.
Okay.
Absolutely. We think that's why all these amendments were necessary. Because even earlier on, before the 2008 amendment, I think there was some discussion in the conservatorship of Jones case, which was in 2004. There was discussion about, well, maybe if the decree was entered before the child turned 18, that makes a difference. But then the amendment the last provided however clause in 101K2 took care of that. And as we said in our brief, that put the lie to any suggestion that a decree had to have been entered before the child turned 18.
And in this case, Judge Hagan clearly stated that the order is modifiable because it said, Father, you can even come back if your financial situation changes.
Exactly, exactly. Again, more discretion built in there.
All right.
There are no other questions?
Well, one of the components here, as I understand it, is father's financial ability to satisfy this continuing obligation. So what findings can I look to in the court's order to determine that the father is in fact financially able?
Well, the father participated in all of these proceedings. He participated in the conservatorship proceeding. He participated in the proceedings regarding the continuation of child support, and he participated in the deposition of Dr. Steves. All along this process, the father never made any arguments that he's unable to pay the continuation of the $700 a month. And so there's nothing that the appellant has put into the record to suggest that he cannot pay that amount.
So
We think the burden's on the appellant to have shown
I
that.
see. And so even though K2 does say that one of the component is the obligor is financially able, the court really doesn't have to say anything about that?
Well, the court can say something about that. It's just that we don't think that the appellant put forward any proof to suggest,
To put it at issue.
yeah, that he's unable to make those payments.
I have a vague recollection that there's an order, and I think it was Judge Hagan, that said the father doesn't have the ability to pay all of the needs of the child, but can pay this award.
The 700.
Yeah, that's my recollection. Is that in the record? Or?
Possibly, Your Honor. I'll concede that I don't
Yeah,
remember that
I
exactly.
have a vague recollection. It could have been Judge Byrd when she had the case, but I'll look. All right. Thank you.
Thank you, Your Honor.
Anything further? Thank you very much. All right, Mr. Wills, your rebuttal.
Yes, Your Honor. Thank you. Just briefly, Your Honors, I'll point out that 36.5 101K2 does say the court may use the child support guidelines. Without having a particular citation to the record for the question you asked counsel about Judge Hagan's order on my client's ability to pay, the final order was a more speculation because there was no child support guidelines used. In the record, there are financial or income records. And again, I think that part of the problem with the statute is that the court may use the child support guidelines. It doesn't say shall use. And then we deviate, of course, from a child of minority to an adult dependent.
Did Judge Hagan change the amount of support that your client was to continue paying, or did he just say it will continue and it's not terminated at the age of 25?
Judge Hagan held that the marital dissolution agreement was unenforceable, awarded retroactive support, and then ordered $700 indefinite. And so,
But was the $700 the amount that your client was previously paying?
yes.
That's what I thought. Okay. Thank you.
So really, I don't have a lot of rebuttal to counsel, but I just want to reiterate the overarching point here is we do have this marital dissolution agreement entered into prior to the child becoming age of majority. Judge Hagan said it's unenforceable, and it's our position that the judge erred in making that decision. With that, unless you have any other questions, I'll submit on brief.
All right. Thank you
Thank
very
you, Your
much, Mr. Wills and Ms. McCarter, for your arguments. We will take this matter under advisement. Call the next case, please.
N. Ray Bravon K.